I want to thank you for watching this video. I think over 90% of Texas voters have no clue that we amend our state constitution every 2 years and sometimes every year. It's always amended in odd-numbered years as a result of the convening Texas State Legislature who drafts these proposals. And this is the only opportunity for the people to have a direct vote in the state legislative process. Very few people vote on these propositions, so those who do vote carry much more weight when you show up and cast a ballot. In the last 10 years, there have been several amendments having to do with property taxes, and this year is no exception. This year we have 2 propositions dealing with property taxes. All proposals to amend the Texas Constitution are passed by the legislature first in the form of a joint resolution, be it a House joint resolution or a Senate joint resolution. And oftentimes an amendment proposal requires Texas laws to be changed to put the governing action into the proposed amendment. In this case, there will be what is called enabling legislation in the form of a House bill or a Senate bill. If and when the proposed amendment is passed by Texas voters at the ballot box in November, then any applicable enabling legislation becomes effective. Basically, it becomes law, part of statute. If a proposed amendment fails at the ballot box, the applicable enabling legislation dies. I have a 3-question test that I apply to all legislation and government actions from the City Council all the way up to the federal body. And I explain why I use these 3 questions on my website, ntcl, NorthTexasCitizensLobby.org. You will find a link to that in the descriptions below this YouTube video. So today, as I go through the 7 proposed amendments, I will put each of the amendments through this test. So let's start with Prop 1. Prop 1 will authorize property tax exemptions for partially disabled veterans or their surviving spouses whose homes were donated to them by charity for less than the prevailing market value. Currently, the tax exemption only applies to homes donated to them at no cost to the veteran. Prop 1 would expand that property tax exemption to homes donated at some cost to the disabled veteran in an amount that is not more than 50% of the good faith estimate of the market value. While this sounds harmless and an honorable way to help our veterans, let's review the history of property tax exemptions extended to our vets and their surviving spouses through previous constitutional amendments over the past 7 years. In 2007, a constitutional amendment passed to exempt all or part of homestead property taxes for veterans having a service-related disability of 100%. In 2009, a law, not a constitutional amendment, passed by the legislature. It exempted 100% of property taxes of 100% totally disabled veterans with a service-connected disability. And in 2011, a constitutional amendment passed to exempt 100% of property taxes of their surviving spouses of 100% disabled veterans, an inheritance, if you will, of the exemption that was passed in 2007. But this exemption at the time only applied to the surviving spouses of eligible disabled veterans who died on or after January 1st of 2010. In 2013, another constitutional amendment passed allowing the exemption amount to follow the surviving spouse to a new homestead. And there is no sunset provision or value threshold for young widows and children. They could avoid property taxes for a lifetime if their surviving spouse does not remarry. In 2015, another amendment removed the date of death restriction regarding disabled veterans so that all surviving spouses now inherit the exemption. And it's estimated that the number of qualifying homesteads increased by 3,800 in Texas in that year through this amendment. For those taxing districts with higher populations of disabled veterans, the state subsidizes these cities with taxes from other districts. And this 2015 homestead exemption is available to all surviving spouses that moved to Texas from other states. Now, while we have much respect for our veterans, every 2 years voters approve laying more and more tax burden on fewer and fewer property owners by carving out special entitlements for groups that the legislature determines to be on the receiving end of social and economical injustices, not to mention the numerous tax abatements our municipalities grant to corporations, large and small, to entice them to locate in our communities. So shrinking the pool of property owners to pay the taxes increases the burden on the remaining property owners. Prop 1 would also include surviving spouses as long as they do not remarry. And I would like to share with you that Prop 1 passed unanimously in both the House and the Senate. So let's put Prop 1 through my 3-question test. Is it constitutional? Does it support our constitutional republic? The answer is no. It selectively supports the life, liberty, and property of certain homesteaders, increasing the burden on those not qualifying for the exemption. Is there a need? Do all the people have a need for and benefit from the proposed government intervention? No. Again, selectively, this creates a special class of homesteaders at the expense of those not qualifying for the exemption. Is it affordable? Can the people afford it, and is the cost equal and uniform? No. It selectively benefits a special class of homestead property owners and increases the perpetual funding burden to non-exempt property owners. Keep in mind that this also increases the tax burden on the many veterans who rent their homes. In other words, they do not qualify for the annual cap on property appraisals for taxing purposes. The answer to the property tax question is to abolish property taxes on all residences to prevent everyone from being taxed out of a home. So let's move on to Prop 2. Proposition 2 is confusing for even those consumers who have purchased a home or refinanced a home. It lowers certain limits and raises others on home equity loans. In summary, Prop 2 rearranges the deck chairs. Proponents say it increases access to home equity loans and places caps on certain fees, and opponents say it disguises the potential for lender fee increases and would allow conversion of a home equity loan back to a purchase money loan, which lacks the protections from forced sales of the home. I suggest reading 2 reports, one published by the House Research Organization and the other by the Texas Legislative Council, which you can find links to both of those publications in the description below this YouTube video. So I'm going to put this through my 3-question test. Does it support the constitutional republic? No. If, as the reports that I mentioned, as they state, since property ownership is the bedrock of our republic, it shall be protected at all costs. And if the opponents that are quoted in the 2 publications that I mentioned are correct, Prop 2 would actually erase constitutional protections for homeowners, which were carefully negotiated when home equity loans were first authorized. And it would disguise the potential for lender fee increases because the amendment excludes from the calculation of the fee cap the items that generally represent the highest upfront costs, that of third-party appraisals, surveys, title insurance, and title examination reports. Lenders would have greater incentive to increase their own origination fees despite the 2% limit, and Prop 2 increases the prospective profits from loan origination fees and would encourage improvident lending. Lenders could later sell badly performing loans on the secondary market, such as was the behavior that contributed to the 2007-2009 recession. Question 2. Is there a need? Do all the people have a need for and benefit from the proposed government intervention? The answer is no. Is it affordable? Can the people afford it? Is the cost equal and uniform? No. Not if purchasers and lenders are encouraged to repeat the behavior that contributed to the housing recession of 2007 through 2009. And Proposition 2 passed unanimously in both the House and the Senate. Moving on to Proposition 3. The constitutional amendment limiting the service of certain office holders appointed by the governor and confirmed by the Senate after the expiration of the person's term of office. Members of most Texas boards and commissions appointed by the governor serve 6-year staggered terms, with 1/3 of the terms expiring every 2 years and most terms expiring in odd-numbered years, the same years in which the Texas Legislature is in session. The appointment process for most boards and commissions requires Senate confirmation of the governor's nominees. Currently, the Texas Constitution requires that an officer within the state continue to perform the duties of office until the officer's successor is qualified for office, including after the officer's term expires. Prop 3 will create an exception to the requirement that state officers continue to perform their duties until their successors are duly qualified, and the exception would apply to officers who do not receive a salary. So on to the test. Does it support the constitutional republic? Yes. The Texas Constitution requires the governor to make hundreds of appointments to his executive department every 2 years. Is there a need? Do all the people have a need for and benefit from the proposed government intervention? Well, I'm neutral, and I could say yes on that. If the removal of time limits on the appointments to non-salaried positions improves the efficient and just operation of the Texas government, then I say yes. Is it affordable? Can the people afford it? And is the cost equal and uniform? Yes. This change only applies to non-salaried appointments. Proposition 3 passed unanimously in the Senate, but in the House it was passed by 142 yeas and 4 nays. The nay votes were from Republicans, that being Craddock, Isaac, Murr, and Rainey. I try to watch committee hearings to hear both sides of these proposed amendments, and this was not possible for Prop 3 or the other two, as there were no questions posed from the committee members in the Senate Committee on State Affairs or any testimony supplied. And the House committee hearing met in a room without video footage, and the minutes posted show no testimony was heard. So, therefore, I had to rely a lot on these reports from the House Research Organization and the Texas Legislative Council, as well as reading the enabling legislation that was behind it. So let's move on to Prop 4. Prop 4 will require a court to provide notice to the Texas Attorney General of a challenge to the constitutionality of a state statute in their court, and will also prescribe a waiting period before the court can render an opinion so that the state Attorney General would have more time to get involved. Well, in watching the Senate committee hearing, the author of the bill, Senator Judith Zaffirini, who's a lawyer, claimed that Prop 4 would, quote, would ensure that a state statute could not be struck down without the state's chief attorney, the Attorney General, having a fair opportunity to defend it, closed quote. The bill was passed in the Senate with 1 nay vote, that was Senator Bob Hall, and in the House with 9 nay votes. And I reached out to Senator Hall and some of the House reps that I know who voted nay. Representative Matt Rinaldi, a lawyer, is the only legislator that responded, and I'm going to read his response to why I asked that he voted no. Now, this is a long quote, so I'll indicate when it ends. And since this was on Facebook, it's public information, so I don't feel like I need to ask Matt if I can share this with you. This is what Matt said. I don't think that if someone sues you to enforce a statute that is unconstitutional, that you should have to wait 45 days before getting the claim dismissed. This is often used offensively to increase your legal fees and prolong litigation. The reason why the proposal is a constitutional amendment is because they passed it as a law originally, and it was held to be unconstitutional. And he continues on to say, if someone is trying to apply an unconstitutional law against you, do you think that you should have to notify the Attorney General and wait 45 days before you can even make the argument in court while you continue to pay your lawyers? Or do you think you should be able to make the argument that the law is unconstitutional and get the case dismissed? If the latter, vote no. And then he goes on to say, the argument in favor is that the Attorney General should get notice of your argument in case he wants to intervene to argue for the law. But this rarely happens, and the only time it would be setting precedent is on appeal, where he would have notice by monitoring the filings. Closed quote. So when Representative Rinaldi was asked what happened to make this a law that is needed, he replied, I don't think that it's needed personally, but what happened was the original law was declared unconstitutional, which is why they are trying to change the Constitution to allow it. So let's go on to my 3 questions. Is it constitutional? Well, I say no, not if this blurs the lines between the 3 separate branches of Texas government and causes unwarranted delay in due process. And you may not be aware that the Texas AG is part of the executive branch, not judicial. Question 2, is there a need? Do all the people have a need for and benefit from the proposed government intervention? Well, I'm neutral on that. Can the people afford it? Is the cost equal and uniform? No. If Representative Rinaldi's example is used, Prop 4 would increase the cost of due process to those initiating a court action. So we'll move on now to Prop 5. The constitutional amendment on professional sports team charitable foundations conducting charitable raffles. Now there's much more to this amendment than the brief description on the screen, even though I think it's the shortest proposition that you'll see on the ballot. So allow me to give you just a brief overview. Here's a brief overview of the history of government-approved charitable raffles in Texas. In 1989, charitable raffles were approved by voters. Texas law establishes how charitable raffles must be conducted and who may hold them. Currently, the Constitution requires the state legislature to enact laws prohibiting lotteries and gift enterprises, with exceptions, and those exceptions are the state lottery, charitable bingo, and charitable raffles. In 2015, voters approved a constitutional amendment including certain charitable foundations associated with certain named professional sports teams. Those were defined as Texas professional sports teams that belong to, and you can see them on the screen there, Major League Baseball, National Basketball Association, National Hockey League, National Football League, and the Major League Soccer. Prop 5 would expand those professional sports teams' charitable foundations to include teams that belong to 13 organizations. And I'm going to list them for you. The American Hockey League, the East Coast Hockey League, the American Association of Independent Professional Baseball, Atlantic League of Professional Baseball, Minor League Baseball, the National Basketball Association Development League, National Women's Soccer League, Major Arena Soccer League, United Soccer League, Women's National Basketball Association, NASCAR, IndyCar, or another nationally recognized motorsports racing association at a venue in this state with a permanent seating capacity of not less than 75,000 and an organization hosting a PGA event. Prop 5 also removes cash-only transactions and now would allow debit cards for purchases of raffle tickets. So let's go to the 3-question test. Is it constitutional? I'm neutral on that. Government shouldn't be in the business of deciding who participates in charity in the first place. Is there a need? Do all the people have a need for and benefit from the proposed government intervention? I say no. Is it affordable? Can all the people afford it? And is the cost equal and uniform? I say, well, yes, because government is not forcing anyone to participate. However, there is a government cost to administer and police the authorized activity. Prop 5 passed in the House 110 to 12, the nays being all Republicans, and 26 to 4 in the Senate, all 6 nays being Republicans. I asked my senator why he voted against this proposition, and his response was that there hasn't been sufficient history since the 2015 amendment, so there's not a track record with which to make an educated decision on these raffles, and that more time is needed. And the 2015 amendment went into effect in 2016, and I'm sure that there was some time in between there where everything got into place. So that's Prop 5. Let's move on to Prop 6. The constitutional amendment authorizing the legislature to provide for an exemption from ad valorem taxation of all or part of the market value of the residence homestead of the surviving spouse of a first responder who is killed or fatally injured in the line of duty. Now, fatally injured, they have that in there because that means that the responder could die later as a result of actions taken while performing official on-the-job duties. I read the enabling legislation that will go into effect should Prop 6 pass in November to answer certain questions. And the enabling legislation, Senate Bill 15, states, and I will quote, "The surviving spouse of a first responder who is killed or fatally injured in the line of duty is entitled to an exemption from taxation of the total appraised value of the surviving spouse's residence homestead, as long as the spouse does not remarry. This exemption value can be transferred to another homestead should the spouse move, and this exemption will be retroactive to include all current spouses of deceased first responders. And I also looked up the definition of first responder, and here's the kicker. There are more than 17 categories of government personnel that will qualify for this tax exemption. And let me list them for you. Peace officer, paid probation officer, parole officer, paid jailer, organized police reserve or auxiliary union, employees of the Correctional Institutions Division, jailer or guard of a county jail, juvenile correctional employee, employee of the Department of Aging and Disability Services or Department of State Health Services who works at the department's maximum security unit, an individual certified by the Texas Commission on Fire Protection, an individual whose principal duties are aircraft crash and rescue firefighting, member of an organized volunteer firefighting unit, anyone who performs emergency medical services or operates an ambulance, or a chaplain for these, a volunteer firefighting unit, law enforcement agency, or the Texas Department of Criminal Justice. It goes on, a trainee employed by the state or political subdivision for any of the positions listed, or someone employed by the Department of Public Safety and deployed into the field to support law enforcement operations, or someone employed by the Parks and Wildlife and assists in law enforcement. Proposition 6 is retroactive for all surviving spouses of first responders, and Senator Huffines, the author of the enabling legislation for Proposition 6, stated that it's estimated that 1,800 spouses would qualify when Prop 6 passes. So to summarize, if their surviving spouse remarries, they lose the tax exemption, and surviving spouses moving to Texas from another state will qualify for the exemption. And the Legislative Budget Board has their cost analysis for Prop 6 available online, and they estimate the revenue loss for each year from now through to 2022 for the following government entities: the Foundation School Fund, the local school districts, the counties, and the cities. And I've provided the internet link to this report on YouTube below this video. Prop 6 passed unanimously in both the House and Senate. So let's put it through my 3-question test. Is it constitutional? Does it support our constitutional republic? No. Although everyone wants to show gratitude to anyone who puts their life on the line in their work, whether it be for the government or for private industry, increasing the tax burden on a shrinking number of homesteaders is not the answer, regardless of how few or how many would fit into this exemption category. All property taxes should be abolished. Is there a need? Do all the people have a need and benefit from the proposed government intervention? No, not all property owners will qualify for this exemption. And can all the people afford it, and is the cost equal and uniform? No. Prop 6 increases the tax burden on those not fitting the definition of spouse of deceased first responder. Now let's move on to the final one, Proposition number 7, the constitutional amendment relating to legislative authority to permit credit unions and other financial institutions to award prizes by lot to promote savings. As I mentioned in reviewing Prop 5 earlier, the Texas Constitution requires the legislature to prohibit lotteries and gift enterprises in the state with certain exceptions, those being the state lottery, charitable bingo games, and charitable raffles conducted by various nonprofit or religious organizations. The enabling legislation behind Prop 7 passed the legislature 2 years ago, but it was vetoed by Governor Abbott. Abbott claimed that the bill violated the Texas Constitution and would need to be passed by voters as an amendment to the Constitution. So, Representative Eric Johnson resubmitted the bill as a constitutional amendment this year. Prop 7 would permit credit unions and other financial institutions to conduct promotional raffles to encourage savings. And in reading the enabling legislation for Prop 7, financial institution is defined as a bank, savings association, or savings bank maintaining an office, branch, or agency office in this state. And savings promotion raffle is defined as a raffle conducted by a credit union or financial institution in which the sole action required for a chance of winning a designated prize is the deposit of at least a specified amount of money in a savings account or other savings program offered by the credit union or financial institution. And it goes on to say, a financial institution may not limit the withdrawal of money from a savings account or other savings program that is subject to a savings promotion raffle. But the institution may, quote, it may require a deposit of an amount of money to remain in a savings account or other savings program for a certain period of time in order for the deposit to represent an entry in a savings promotion raffle, and a financial institution shall pay interest or dividends consistent with the interest or dividend rate that the financial institution pays on comparable savings accounts or saving programs that are not subject to a savings promotion raffle. There was no opposition filed in either the House committee hearing or the Senate hearing, and no debate on the floor of either chamber. However, the Texas Research Organization claimed that there were opponents claiming that it would allow certain institutions to be the only non-charitable institutions allowed to conduct such raffles. This is basically for your individuals who have never exercised saving money. It's to try to encourage people to get in the habit of putting money into a bank, a savings account, or whatever. It has some wonderful merits and wonderful intentions. But let's throw it through my 3-question test. Is it constitutional? I'm neutral on that because there's questions as to what business the state has in deciding such transactions that carry little to no risk for the consumer. Is there a need? Do all the people have a need and benefit from the proposed government intervention? I say no. Is it affordable? Can all the people afford it? And is it equal and uniform? Well, reportedly there is no cost to the consumer, just a business expense to the financial institution. Prop 7 passed unanimously in the House and passed with 1 nay vote in the Senate. And I contacted that senator to find out why there was a no vote that was lodged. And that senator's staff said that the senator opposed the bill because the operation of raffles for any purpose constitute a game of chance played for a monetary reward, which is gambling. While this legislation does not permit casino-style gambling, it further normalizes games of chance played for money that is against the spirit of the state's constitutional ban on gambling. Closed quote. Well, that concludes my brief review of the 7 proposed amendment. Please get a copy of the summaries published by the House Research Organization and that of the Texas Legislative Council, and I suggest that you phone your state House rep and your state senator with any questions that you have. They voted on these proposals, and most of them voted for these to be on your ballot. Ask them why they support them. And if they tell you that they just voted for it so that you can decide at the ballot box, ask them if they would vote for a proposal to abolish the First or Second Amendment just so that you could decide. Please don't let them off the hook. Their votes should reflect their positions. It's all that you have to decide if they deserve your vote in the next election cycle. If you haven't registered to vote anywhere in Texas, your registration must be received by your county elections department by October 10th. And if you've moved since the last time you voted, update your address as soon as possible with your county elections administrator so that there won't be any issues on Election Day. Early voting is from October 23rd to November 3rd, and Election Day is November 7th on a Tuesday. So I hope I've given you enough information to pique your interest in performing your own research into these important amendments and show up to vote your position. Only 11% of Texas registered voters voted in the last constitutional amendment elected. Your vote counts. Our current Constitution is over 200 pages in length. In its original form, when adopted in 1876, it was 50 pages. And you can find a link to the 1876 and the 2016 Texas Constitutions below this YouTube video. God's blessings to our Texas.